I'm Emily Owens. Welcome to my Introduction to Employment Law for Human Resources 605. A little bit about me before we begin. I've been a military spouse for 15 years. My husband is active duty Air Force, and we've been stationed here in Monterey, California twice, San Angelo, Texas, and Omaha, Nebraska. We will be going to our new base in Tucson, Arizona in a few months, just a half hour from where I grew up. I've been a barista for 3 years and worked at Starbucks for 2 of those years. Starbucks College Achievement Plan helped to pay for a portion of my tuition toward my bachelor's degree in history. We are aware of the many benefits and perks that comes with working for Starbucks. Now we can move on to the laws and regulations that help Starbucks succeed as a company and an employer. What is employment law? It is a set of policies and regulation created by the federal and state governments that companies and their employees must abide by. These laws help keep our stores a safe space for everyone and protects both the company from lawsuit while also protecting the employee's rights. You can read about many of Starbucks' specific policies in our Business Practices Manual and Employee Guidebook. There are several regulations that we will briefly touch on in this presentation. We will address the Civil Rights Act, which protects workers from discrimination in the workplace. Then we will discuss the Americans with Disabilities Act. It protects Americans with disabilities from discrimination and requires employers to provide reasonable accommodations for their disabled employees. We will also talk about the Age Discrimination in Employment Act, which prohibits discrimination against employees based on age. The Fair Labor Standards Act provides regulations for safety, wages, overtime, pay, breaks, as well as other things that keep our employees safe. The Family and Medical Leave Act gives qualified employees up to 12 weeks of leave in the event of an illness or injury to them or a family member. Title VII of the Civil Rights Act of 1964 is a law that protects against discrimination based on race, color, gender, religion, sex, national origin, and disability status in the workplace. It was amended in 2009 to include people with disabilities as well. Those who violate this law risk being fired, fined, or imprisoned. The Americans with Disabilities Act, or ADA, was passed by President George H.W. Bush in 1990 to protect disabled Americans from discrimination. Having a disability is not grounds for refusal to hire a qualified applicant. Neither can you fire an employee for being disabled, nor pay them a lower wage due to their disability. Employers must provide reasonable accommodations for their disabled employees. Some examples of these reasonable accommodations that I've seen here at Starbucks are interpreters for deaf or hard of hearing baristas, stools for injured partners to sit down, and gloves or personal protective equipment for partners with allergies. Federal and state laws provide the guidelines for a minimum wage, benefits, and safety standards that employees are entitled to. As a company, we can see that Starbucks tries to go above and beyond to meet the needs of their employees. In this slide, you can see that the state requirement for minimum wage is $14 per hour, while Starbucks starting pay is now set at $15.50. California law says that employees qualify for benefits once the work reaches 30 hours a week, while Starbucks qualifying hours amount to just 20 hours a week in order to receive these benefits. Employers are expected to provide basic health, dental, and possibly vision benefits. Starbucks provides a tier level of benefits, but they include the aforementioned health, dental, and vision, plus tuition for the SCAP program, or the Starbucks College Achievement Program. Also, IVF, in vitro fertilization, or adoption grants for employees trying to have a child, as well as the CUP Fund that provides grants for partners in need. We also abide by OSHA like other companies in the U.S., but we've added another level of quality control and safety through Quasi. How does the ACA, or Affordable Care Act, apply to our partners here at Starbucks? In short, it kind of doesn't. Starbucks already provides superb healthcare programs that fit the employee's budget and needs. In fact, the company worked to absorb any extra cost to avoid burdening its employees so that we can take advantage of the benefits of the ACA. We continue to offer benefits to employees after they reach 160 hours in a 2-month time period, which equals about 20 hours of work a week. Instead, we've seen the expanded benefits in terms of improved access to providers and children remaining on partners' insurance until they reach 26 years of age. If a partner is no longer employed with Starbucks, they won't be denied health coverage based on pre-existing conditions. The Wages and Fair Labor Standards Act entitles workers to receive at least the federal minimum wage. Although we've already discussed that Starbucks tries to exceed the minimum, this law also sets overtime pay at time and a half of the partner's pay rate. According to this law, managers are required to keep track and record time worked, including any overtime or paid leave. It also provides regulation regarding minors, including how many hours they can work. Starbucks partners under the age of 18 may not work for more than 4 hours on a school day past 8 p.m. or more than 20 hours per week. The Equal Pay Act of 1963 was put in place to ensure that employees receive equal pay for equal work, regardless of gender. This bill aimed to close the gender wage gap and prohibits wage discrimination based on sex. This means that 2 equally qualified employees working equal jobs with equal tenure deserve equal pay. The Employee Retirement Income Security Act of 1974, or ERISA, is a law that interested employees are entitled to a retirement plan. All of our partners should be updated on information regarding available retirement plans at the beginning of employment and as any changes are made. We also outline the different plans offered so that our partners may have the information necessary to make the best choice for them. The National Labor Relations Act of 1935, or Wagner Act, and the Taft-Hartley Act of 1947 guarantees the right to assemblage as well as the right to not be forced into joining any union on condition of employment. Any partner that joins a union is free to do so and is protected from retaliation and may not be coerced, nor may they be coerced into joining one. So far, there's only one unionized Starbucks store. Arbitration agreements are documents that new hires may sign electronically during onboarding and help protect the company and its partners from unnecessary fees and court cases. These agreements are meant to help process partner disputes more quickly and efficiently to avoid court. They are not meant to forbid partners from filing disputes with the National Labor Relations Board. They also do not allow retaliation against partners who file a dispute, nor does this agreement restrict the rights of any employee involved in the dispute. In conclusion, all Starbucks partners must follow federal and state laws, regulations, and guidelines, regardless of position or rank within the company. Starbucks works to create a safe and enjoyable place for both patrons and partners and as a company. Starbucks strives to show that we are willing to go above and beyond to meet the needs of all of our employees.